Now we shall discuss the categories of the evidence. The first is direct and circumstantial evidence of material facts. Direct evidence is given by the person who was actively at the crime scene, who was supposed to be at the crime scene and had the direct experience of the crime. For example, if a person is at a shop and a robbery occurred at that shop, the customer and the seller both can give direct evidence. The evidence given by both of them shall be the direct evidence. In comparison, the circumstantial evidence could be the evidence that was given by the pedestrian. It is the evidence of the person who was not supposed to be there but happened to be there by chance. Moreover, the evidence taken from the crime scene, like the fingerprints of the person who did the robbery, who committed the robbery, is also circumstantial evidence. Second category is the evidence of the background of material facts. It is unhelpful to state facts in meaningless isolation. You are got to be able to fill in the background circumstances and events for the jury to make sense of it. For example, you cannot say stuff like something has happened and happened and happened. You have to give evidence, and that evidence shall bridge the gap. That evidence is supposed to bridge the gap of what you are saying. And judge has the power, if you are saying something that is irrelevant to the case, to intervene. The other thing is the evidence of collateral facts. Collateral facts are facts which help in assessing evidence which is relevant to the material facts. Facts which affects the witness's credibility. Like if a person who is a habitual offender, the previous evidence or the previous occurrence that he has done, he has committed the crimes, shall thrash his credibility. So that is collateral evidence related to the facts. The other thing is facts which affect the admissibility of the evidence. The next is hearsay evidence. One of the characteristics of adversarial system is the giving of oral evidence before judge, jury, and the examination and cross-examination of witnesses. So cross-examination and examination in chief is quite important in common law jurisdiction. So if someone has to say that something is correct and it is correct on the ground that he has seen it, so the other party has the right to cross-examine that person and to thresh the credibility of that person. It has traditionally been considered important that a judge or jury should be able to see the witness give evidence, and other side should have the opportunity to test the evidence. The other side has the opportunity, should have the opportunity to test the evidence by robust cross-examination, because otherwise you are just making an allegation if you haven't gone through cross-examination. If you have gone through cross-examination, then your allegation could be relied upon. It follows that if a party wants to rely on particular witnesses' evidence, that party must produce a witness at the court, rather than simply read out the statement made by that witness or get someone else to say what the witness would say. Evidence of what witness included in the witness statement or said by to someone else is likely to be classified as hearsay evidence. And general rule of hearsay evidence is that it is not admissible in the court of law unless it is expert evidence.